although there's a prohibition against age discrimination, age does play a role. For example, if there are certain state laws prohibit minors from doing certain jobs, obviously that's not going to be contrary to the Anti-Discrimination Act. And in some circumstances, where there's compulsory retirement at age 65, for example, for someone in the high earning category that will be guaranteed at least $44,000 per year in their retirement. So the Act also provides for certain remedies for non-compliance. The administrative procedure, and this is where some of the changes have come about in just the past year or two. The administrative procedure is the exclusive remedy under Utah law. The employee can file a charge of discrimination with the Utah Anti-Discrimination Division. The 2018 amendment calls for voluntary mediation before the division begins its investigation, and that's different. It used to be that they would do their investigation and then they may have voluntary mediation. Of course, employees don't need employers. It's all voluntary, so if either the employer or the employee doesn't want to do it, they don't have to. But after their audit of a couple of years ago, they were trying to make some changes so that they could be more proactive in handling these cases. Interestingly, we were talking a little bit about this at the break. I was looking at some statistics, and the Utah Anti-Discrimination Division only found about 2% of all of the charges filed as being meritorious. That's actually about a percentage point lower than what we see at the federal level. So the vast majority of these claims are found to be non-meritorious. That doesn't necessarily mean that if they go into litigation that the court will see it the same way or the jury will see it the same way, but that's an interesting point. Either party can request a hearing before a Utah Labor Commission administrative law judge. The judge's order may be appealed to the commission as a whole or to the commissioner. Either party can request judicial review of the commissioner's order. A charging party can withdraw from the process at any time, get their right to sue letter, and go ahead and file with the EEOC or in the court system. So remedies allowed by our law include injunctive relief, reinstatement, back wages, benefits, attorney's fees, and costs. I'm not going to go into too many details about amendments that were made to the Governmental Immunities Act this past year, because in some respects they're kind of convoluted and a little bit difficult to understand. But be aware that basically what these amendments dealt with primarily were the notice provisions of the Act. And now there is an affirmative responsibility on the part of the governmental entity to advise the plaintiff that their notice of claim was filed with the wrong party at the wrong address, and they have to give them the right party and the right address. Also, there's an affirmative duty on the part of the counties in this situation to file with the Division of Corporations and Commercial Code at the Department of Commerce the name and address of the governmental entity, the office or agent designated to receive notices of claim, the address at which the notice of claim is to be directed and delivered. And so those have to be updated. So it's really the notice thing. There were also some changes that were made to the bond that the plaintiff has to file. And I think probably for the most part that's something that you don't have to deal with too much, so we won't go into too much detail about that. I wanted to mention, and you tell me when I'm talking too much. Okay, we got to run through this. Sorry. They told me that you were ahead of schedule. Well, I usually know how to make a deal with that, So anyway, the genetic testing restrictions on Employers Act, that's another act in Utah, and it prohibits employers from asking about or considering private genetic information about an employee or prospective employee in decisions regarding hiring, promoting, or retaining. except when the employer has a reasonable basis to believe that the individual's health condition poses a real and unjustifiable safety risk requiring a change or denial of certain job duties and assignments. And I think probably most of you are familiar with this, and I think this is going to be an area where things are going to evolve and change because of how much more information is available to each and every one of us involved in this, but that was something I just wanted to mention. Some of the ones that I think are really interesting, and I was involved in a couple of matters in another county dealing with emails, and some of these laws kind of touch on that, but I wanted to mention this to you. There was actually a complaint that was lodged against a human resources director for one of the counties that she had accessed these employees' emails, and it was contrary to Utah law. A couple of things that are important to point out there, even though they were sharing what might be considered personal information, it was on the county's system, on the county's time, and one of the employees had even left the county's employment, and this was some archival information. It was my position, and let me know if you see this differently, that while it's on government time, using government system, using the government's email addresses, that that person does not have that expectation of privacy, and that is in fact a government record. It was pretty hotly debated though, but I think that that's the right decision from my perspective. Does anybody have a different point of view on that? Well, I think this also goes to the importance of education and the importance of policies and procedures manuals where that is specifically laid out there. Now, on the other hand, in this situation, if one of those emails was going to a person's attorney talking about about a claim against the county or something like that, does that fall into that same category, or is that a little bit more in the gray area? In my opinion, that makes it into the gray area, even though I think that the rock solid position is that county time, county system, county's emails, county employees, and so on and so forth. If you see that it's going to the attorney, my recommendation to you would be to immediately get out of it, immediately notify the person that this has occurred, because I think that attorney-client privileged information, even though what the employee did was inappropriate and probably would be found by a court of law of them actually waiving their attorney-client privilege by doing that, I think it's the appropriate thing to do. So that gets us into some of these other technologies. The Internet Employment Privacy Act prohibits employers from asking or disciplining employees because they will not disclose usernames and passwords to their personal internet accounts. It also creates a private right of action for violation of the statute and a fine of not more than $500. Again, my interpretation of this law, it does not apply to a situation where the employer provided the telephone, provided the computer, and so on. I think that in those situations, and I think the law actually addresses this, the employee is obligated to disclose usernames and passwords and so on and so forth. But if it's strictly their own iPhone or their own computer or what have you, and they're in this pre-employment phase, you cannot require them to disclose this information, and you cannot use that against them if they tell you that they will not do that. However, I think there's no prohibition about looking at what's out there in the public domain. If somebody has things out there in the public domain, I think that you don't have an expectation of privacy in that regard. Any thoughts on that, or any difference? Okay. And I'm going to skip over jury service and military leave. I think you're all aware of the fact that you can't discipline an employee for taking time off for jury service or military leave. Drug and alcohol testing, I know that we talked a little bit about this during the last presentation, and this protects employers who conduct drug and alcohol testing from liability if they follow the criteria set forth in the statute. Employers may test after a conditional offer of employment if they do so for all prospective employees. You can't single out and say, well, we're going to drug and alcohol test all of the men applicants that are under the age of 22 or something like that. You can't do that. It has to be across the board. Employers may test after on-the-job injuries and accidents if they do it with all employees who fall into this category. Employers may do it for just cause. Just cause is a little bit of a dicey issue. So as an employer, you need to set forth pretty specific objective criteria that would constitute just cause so you don't get in trouble there. And again, I would encourage everybody to consult with the attorneys involved with that in order to make sure that you're all okay with what constitutes just cause. Employers may test randomly if they include all employees. Management must submit to drug and alcohol testing on a periodic basis if they're going to test the rank and file employees. Before a test can be considered a failed test and used for denying or terminating employment or disciplining employees, there must be a confirmatory test using state-of-the-art technology and done by a lab that is certified by the United States Department of Health and Human Services. So that's important too. There has to be a written policy when it comes to drug and alcohol testing. If you don't have a written policy about that, then you can't go forward with drug and alcohol testing. And also the employees need to be advised of that. The prospective employees need to be advised of that. They need to be told what you're testing and why you're doing it. So that information has to be given to them. Test results have to be confidential, but can be used in taking action against an employee or to defend claims brought by the employee against the employer. So that's just it in a nutshell. A couple things that I think are relatively new. Employer reference immunity provides for a qualified privilege for an employer who in good faith provides information about an individual's job performance, professional conduct, or evaluation of a former or current employee to a prospective employer at his or her request. It protects the employers a lot because in essence it creates a rebuttable presumption that the employer did it in good faith and when they provided that information. And the presumption can only be rebutted if there's clear and convincing evidence, which is a really high legal standard, and that the employer did it with actual malice and intent to give this prospective employer bad, false, or misleading information. So I think that that's an important thing to keep in mind. Employment Selection Procedure Act, I told you there was a lot there, prohibits employers of 15 or more employees from asking applicants for social security numbers, dates of birth, or driver license number before the applicant is offered a job. There are some exceptions to that. If the applicant consents to the request and the employer asks all applicants for the same information. You can see here, I won't read them all, but there's the list of what that information can be used for, so keep that in mind as well. Interception of communication acts, and this goes to what we were talking about a few minutes ago. It prohibits employers or others from intentionally or knowingly intercepting or trying to intercept either personally or getting someone else to do it, wire, electronic, or oral communications of employees or others. However, employers may intercept such communications if they have the employee's consent to the interception or if they are the other party to the intercepted communication, unless the communications are regarding criminal and tortious acts. So this is a Class A misdemeanor that's violated, and the person claiming his or her rights were violated by this, and they sue for actual damages, including compensatory damages, punitive damages, and/or injunctive relief. Basically, it says you can't spy on your employees. I had a situation in one of the counties where, and this comes into this next one that I wanted to mention to you briefly, privacy violations. It prohibits persons, including employers, from installing or using devices for observing photographic, hearing, recording, amplifying, or broadcasting sounds or events in any private places. And private places is an important thing. I mean, we're talking about restrooms and things like that, but not in the areas where the general public is. Unless they have the consent of the person who are entitled to privacy in those matters. It doesn't matter if the devices are installed inside or outside of private places, and it's a Class B misdemeanor. But back to the story, there was one county where an employee decided was going on vacation and had a camera on the computer, left it running the entire time while she was on vacation. And the question was, what do we do with that? Any thoughts? Do you think it violates this law, or do you think I don't know if we ever figured out if it was inadvertent or if it was on purpose, but I thought that was kind of an interesting thing. If it's in a public area, I don't know if the law really addresses that very clearly, but it was an interesting situation nevertheless. Any thoughts on that? All right. Now there's a lot more to talk about. I've already kept you 3 minutes past when I was supposed to be finished, but I can understand.
Just a quick question on deciding what a private area is. Would an office be considered a public area or a private area?
Generally when I do discrimination training, basically what I say is as long as you're on the four corners of your employer's business, and I think this applies even more so to a government office, I don't think that's considered. You don't necessarily have the expectation of privacy. Obviously, if you're having a closed door session with an employee to discuss performance issues and so on, then I would consider that to be a private conversation, and you took reasonable measures to keep it private. I think what the law contemplates is doing this kind of thing in restrooms or in, I don't know. I mean, it's kind of where there is the expectation of privacy. And I think if you look a lot at least I do, to the discrimination laws that deal with this issue. For example, can an employee have sexually provocative materials at their place of business, at their work? Obviously, they can't have it posted in their cubicle where everybody can see it. And it's my position that they can't have it in their desk drawer because that desk drawer belongs to the employer. And yes, it's probably true that there is some conditional right of privacy within a person's desk at the office. I still think that it's the company property, company premises, and so on and so forth. If they have it in their automobile, I think they have an expectation of privacy there. And that's kind of the distinction we make in Utah law regarding guns in the workplace as well, And so it's, I think you have to go through that kind of an analysis. I don't think it's entirely clear. There was a case that came out of the state of California a number of years ago where a firefighter slept at the firehouse, had his own space in a private room, and had some pornographic material in there. And the question was that something that the employer could discipline him for, being in violation of policy, or was that considered to be a private space? And in California, they said that that was still the employer's property and that he didn't have that expectation of privacy. if it was in a suitcase or in a lunch box or, like I say, a glove box in a car, there is that expectation of privacy. That probably made it as clear as mud to us. So those are, yeah, but they're interesting issues, you know, especially in this day and age with all the social media. Another issue that's come up with one of my other clients is, what do we do if we see that we have a disgruntled employee that goes out on, you know, the internet or on Facebook or what have you, just bashes everybody at work, and other employees respond back. There has been some recent guidance on that in some cases where they say, hey, First Amendment, off company time, off company premises, you can't interfere with that, and you can't use that information against them. A little bit different if it's in the workplace. So there are so many factual nuances to all of those things, but I think this is the next area where we're going to see a lot of litigation because of this clash between privacy rights and employer rights and so on. So, well, with that, if you don't have any other questions, I'll let you go. I'm sure you're all anxious to go and enjoy your day. And thank you so much. And again, I so appreciate working with so many of you and working with UCIP. And if you ever have any questions or concerns, please feel free to give me a call. I'm happy to help with you with any of the problems that you may have, and hopefully they will never amount to any kind of litigation. But if that does happen, we're here for the long haul, right, Julie?
Yes.
and I made some really great friends having to go through some of that, but hopefully we can prevent any litigation going forward. But thanks again so much, and have a great day.
I just want to point out once again the use of members, Alex. I think Alex probably has done a lot of the heavy lifting here in Sonia, of course. If we could just give them one more round. Thank you all for attending. We will please, if you have any comments or suggestions on different topics that you'd like to see at these types of events, please let the team know so that we can make sure that we get that information put together. Thank you very much for being here. Oh, and if you have your evaluations, just leave them on the table at the very back, please.
I didn't do it on this one. I don't